Hey, everybody, welcome to the Legal Hour, where every Tuesday at noon we are joined by attorneys, judges, and other legal professionals to talk about different areas of law, giving you tips and resources in their area of legal expertise. I am your host, Tamika Johnson, estate planning attorney specializing in wills, trust, healthcare directives, power of attorneys, deeds, and uncontested divorces in the state of Georgia. For more information about my services, feel free to visit johnsonlawpractice.com to book a consultation and to learn more about our services. Now, normally we do have a guest on, another attorney or judge, but this week is just me. You get me this week, talking a little bit in depth about estate planning. Our first episode was about estate planning. We kind of went over the process with another attorney, Jamie Smith Tear. But I do want to talk about some ways to avoid probate altogether, because that's something that if people could do, they would, especially after they've been through the process themselves. So we're just going to talk a little bit about, again, some ways to avoid probate for your loved ones. And I really want to start off by saying I know estate planning is one of those things that we don't want to talk about. We have to kind of face the fact that one day we won't be here. It's not something we want to talk about, but it is something that is inevitable for all of us, unfortunately. But we can make it a lot easier, again, on our loved ones, on our families, just the process. Many of you have probably seen just how families have been torn, just confusion when things haven't been put in writing. When you do have to go through probate, it is a process. It's an emotional process, and it could be an expensive process. Somebody is out here cutting the lawn today, so I'm hoping that you all can't hear it that much. But this is not going to be a super long episode. But just I want to give you 4 ways, basically, to avoid the probate process. And one of the first things you can do to avoid probate, if you have a life insurance policy or a retirement account or 401k investment accounts and policies that have beneficiaries listed ahead of time. Those things do not go through probate. And you'll want to make sure the beneficiaries are updated on those policies. So when you do pass, those things automatically go to your listed beneficiaries. So sometimes people get life insurance policies like way, way, way back in the day, many, many years ago, and things may have changed. You may have had children, you may have been single, you may have been married, you may now be divorced, or you may have gotten married. Some of the beneficiaries may have passed themselves. So you want to make sure those policies are current, up to date. And also say this for people who have life insurance policies with their employers, strongly, strongly, strongly suggest getting a separate independent policy. Because if you ever leave your employer, your life insurance policy goes away with your job. And you'll basically have to get a new policy. And as you know, the older you get, the more expensive it is to get those policies. So while you can do it now, get those policies, those separate policies, because in the event, again, you're no longer with your employer for whatever reason. We don't know what's going on in this world, and things just change. People are not just with one employer from the time they graduate high school or college to retirement. It doesn't happen. So it is very likely that you will change jobs and positions. So make sure you get a separate policy. There are plenty of insurance agents and brokers out there that can assist you with that. Sooner the better, though. A payable on death account. If you have a bank account, money market account, savings account, anything with money in it at a financial institution, make sure you get a payable on death form. And what that means, basically, again, when you pass, if you pass, whoever is listed as the beneficiary on that form with your financial institution or your bank, the monies go directly to that person. So it's not the same thing as having them as a joint owner on the account. They don't have any access to the account while you are here. and living, but again, it will bypass the probate process if you have that payable on death form. So it's a very simple process. Again, you can just contact your bank. They may even have it online. I'm not sure. I don't say that with authority. But if nothing else, if you go to the bank itself, they'll send you a form, and you'll have that. So that portion, those monies, those proceeds can go again directly to your beneficiaries or wherever you want to have those proceeds. Real property. So in Georgia, and I've mentioned this before, but in Georgia specifically, because that's where I'm licensed, so that's what I'll speak to. And it may be similar in other states, but you'll just want to check with an attorney out there in those other states if you're in another state. But in Georgia, there is not an automatic transfer of property if you are married and your spouse is on the title with you, or your kids are on the title with you, whoever you have on the title with you, or if you're just on there by yourself. The property does not automatically transfer to the other property. It can. It can bypass probate, your property, your house, your home, any real property, land. It can bypass probate, but it has to have very specific language on the title and on the deed. And as someone who has done thousands and thousands and thousands of real estate closings, I can tell you that that language is not automatically inserted on property deeds, security deeds, warranty deeds. You have to have that specific language. If you do not have that specific language, then the property will be distributed either one according to your will, if you have one. Whoever's remaining on the title will keep their portion, but the other half that you own, that person owns, if you have a will be distributed to whoever you have listed in the will, but that does have to go through probate. If you don't have a will, then it still has to go through probate. It's just a little longer of a process, and again, that's the importance of having a will. But if you don't have a will, then again, half of it will go to whoever is the surviving title holder, and whoever passed, that portion will be divided however the state determines who that person's heirs are. So again, those two, whether if you have a will, don't have a will, there's real property involved, it's got to go through probate, unless one, you have the specific language on your deed allowing for the right of survivorship. Tenants in common is not going to do it if it doesn't say, if it just has your name and let's say your spouse's name. That's not going to do it. You need to have very specific language. So you can check your deed, you can check with your closing attorney, but you'll want to get that resolved so that can just automatically pass or bypass probate in order to be titled in the next person's name. The other exception to that with being able to bypass probate is to have a trust. And that's going to be the fourth way that we're going to talk about today to avoid probate. Anything listed in a will, if you have a will, it goes through probate. If you don't have a will or a trust, your assets have to go through probate. But if you have a trust, then that avoids probate in most cases, unless there's something defective with the trust. But that shouldn't be the case. That's usually not the case. So anything that you have in a trust, it bypasses probate. And it's a more seamless transition. And you can put different things in a trust, but the bigger things are going to be property and money. But you can put antiques in there. You can put baseball cards in it, collections, anything that you want, you really and truly can put in a trust, so it can avoid or bypass probate. However, it is important to note that there is a process to creating a trust and funding the trust. The trust is not simply a piece of paper there are some steps that need to be taken as far as the titling of your property, actually putting it in the name of the trust. Same thing with bank accounts. You'll have to change those things. So there are some steps that you have to do now, but at the end of the day, it saves you a significant, or your loved ones a significant amount of time, and again, money in the process altogether. Trusts do cost more on the front end, um, because there is a little bit more involved into doing that in the creation of that. But it usually saves your loved ones, your heirs, your beneficiaries, time and money on the other side if you don't have a trust. And sometimes it may not make sense. There are some situations where it may not make sense if you all you have is, if you've done everything else, right? Like you have life insurance policies, you have the PODs on your bank account, you have your property listed correctly. There may not be a reason to, you may not have, significant enough assets to put it in a trust, because trusts are a little bit more costly and expensive than wills. But that's determined on a case by case situation. So if I have someone coming to me and all they have is a home and they're a single person, it may not make sense to put it in the trust, because, especially let's say they don't have any kids and they don't have any children, and all they have is a house. It's probably going to be cheaper to go through probate here in Georgia. The fees are not super expensive, but what I would charge for a trust would far outweigh the benefits of not going through probate. So the cost of probating just basically a home, again, if you've done everything else, it may be worth it to go through probate, especially if you don't have any children. Now, if you have minor children, um, or children who are young adults that you don't want them to have access to certain monies at a certain period of time, you don't want them to have access to properties or certain things, then you should still have a trust. And that's not necessarily a probate avoidance thing. It is a benefit of it, but it is to protect your assets. It's to protect your assets for, the children who may not be mature enough. If you have minor children, if you pass, you have minor children, the court will appoint a guardian to look after their interests if you don't have one listed in your will or your trust. But once they turn 18, they have access to whatever you have left them. And so most people don't feel like an 18-year-old, because there's 18-year-olds in college, in high school. Most people don't feel like in high school that an 18-year-old is ready to have a large amount of money or even a home, or what to do with it. So in those situations, you want to have a trust. You can dictate, what point they get access to money and or property. A lot of people, kind of sweet spot the age is about 25, but it could be older. Depending on what you have, it could be 35. You may have adult children who may have had a drug problem, alcohol problem, or something like that. Maybe just gambling problem. It happens. It's unfortunate, but it's real life. And so again, you may not want them to have access to your property, your money, everything you've worked for. And so by creating a trust, you will appoint a trustee who will oversee those things and just kind of distribute money according to the terms of your trust. Now, having a trust, you can still have complete control over your assets and your properties, especially if you have a living trust. It does not mean that you give anything away. You can still be the trustee in it, and when you pass, then everything else kind of takes over. So whoever your successor trustee is, that's when they start performing. But you still have access and control of everything until you pass. Again, the benefit is to avoid probate in that situation. There are different types of trusts, which I won't go into in this video, but you have living trust, you have revocable trust, you have irrevocable trust. And just depending on what you're trying to do, what you're trying to accomplish, that will determine what type of trust you have. Usually when we're doing irrevocable trust, we're looking at more asset protection and exemptions from taxes. In the state of Georgia, there is no inheritance tax, but there is a federal tax, but that amount usually surpasses the average person. So right now, it's definitely into the millions. Once your estate is at over $5-6 million, and that changes. It changes. Congress kind of dictates that according to who's in office, um, whatever those numbers are, and via the IRS. So right now, the average person is not subject to inheritance taxes, even on a federal level. So, but if you do have those kind of assets, then you'll want to look into irrevocable trust and do some more asset protection and planning and avoiding probate. Again, anything that is in a will and anything that you do in probate court is a public record, so people can see what you're putting on there. And there is a requirement to put down the value of assets and property, money, and accounts. So if you don't want that to be seen, if you don't want your loved ones to have to worry about people coming after them because people know what kind of assets they're looking at, then you want to look at a trust as well. Otherwise, everything is public. And my biggest piece of advice would be, as far as estate planning, again, I know no one wants to do it, but I can tell you when I did mine, it's just you have a sense of peace, right? Knowing that things will be taken care of. And you can also create a testamentary trust, which is in the will, meaning it's created when you pass, but it still has to go through your estate does still have to go through probate. Do it while you're still in good health. Do it while you are still in the right frame of mind, because I can't tell you how many calls I've gotten and will continue to get with people being sick, having cancer, dialysis, dementia, those kinds of things happening, and they usually want to get a power of attorney or healthcare directive. And once you reach that point of your life, it's harder to get those things executed. For me personally, I will no longer do any kind of estate planning documents, whether it's a will, whether it's a power of attorney, whether it's a healthcare directive, transferring property. I won't do those things for anyone if they're in the hospital. And that's an emergency situation. And a lot of people wait until that time and try to get things rush. And if that is the case, you may have attorneys who may do them. A lot of attorneys won't. But if you reach that point where someone's already sick, or again, dementia or Alzheimer's, maybe all their faculties may not be there. You're looking at a case where you actually have to go to probate court to get access to someone's funds, taking care of their personal business, paying the mortgage, access to bank accounts, all of that. You've got to go to court by then to get a guardianship and conservatorship. And so do it while you can. Life is short, and we should definitely be enjoying it to the fullest. But we should be planning. We just, you never know. You never know. And just have the peace of mind at knowing that your kids will be okay, your spouse will be okay, and anyone else, your nieces, nephews, your parents, uncles, whoever, cousins, whoever you want listed as a beneficiary. Make sure that they're taken care of now. Make it as seamless as possible, because when you don't have a will, it's going to cost more than if you had a will or a trust. And there's going to be certain requirements as well. You have to file an inventory of the person's all their assets, personal property and real property, itemization of everything that they have. A lot of times you have to get a bond, because it's almost like, well, if a person didn't even at least have a will, we don't know what their intent was. And so we don't know if this person that we're appointing as the administrator is the best person. So they're required to get a bond. The bond is the percentage of the amount of the value of the estate. They've got to do an inventory. They have to file annual returns. And so at least you can have a will, if nothing else. you can um, you can exclude your exempt. I'm sorry, you can exempt your executor from having to do those things. You exempt your executor from having to get a bond, which costs money, to file an inventory, and to file annual returns with the probate court. So, just to kind of summarize the four ways to avoid probate: one, life insurance policies, investment accounts, retirement accounts, those kinds of things. They already are exempt from probate. Just you just want to make sure that those beneficiaries are updated and current. You can also list a trust as a beneficiary in a life insurance policy. So if you want to look into that, just make sure you contact your insurance agent or your insurance provider for life insurance. PODs, payable on death accounts, if you have monies in bank accounts, money market accounts, savings accounts. Those can bypass probate if you do have the payable on death beneficiary designation. And the property, your real property, homes, land, that kind of thing, that can bypass probate, at least in the state of Georgia, if you have the correct title designation on there. Especially if you have two or more people on there. Usually, what's common in our situations is that you're married and if something happens to one spouse, you want to be able to transfer the property automatically to the surviving spouse, and that can't be done unless there is that specific title designation. So you can always call and check if you're in the state of Georgia to see if you do have those correct designations. And if not, then we can get the property transfer so that you do. And last, creating a trust. Trust avoid probate usually all together. So it's for privacy and it's for a seamless transition. So there's not an overseer. You've already taken a step to appoint everyone to see when who gets what and when and where, and just gives clear instructions as to how your property will be distributed. And again, that avoids probate altogether. That is it for today. Next week, we will be back with another attorney, Beverly McNeil, and we'll be talking about Social Security, disability, the requirements, what you need, what they address, appealing the process, all of that. So that's going to be a really good show next week. So I'm excited about that. So stay tuned for that information. Same time next Tuesday at 12 p.m. on the Legal Hour. If you have any questions for me, you are again in the state of Georgia as far as estate planning. You can visit the website at johnsonlawpractice.com. If you are not in the state of Georgia, just be sure to look up an attorney in your area to get your estate plan done. If you don't know anyone, you can always send me an email, contact me through the website, and I can definitely reach out to some other attorneys in other states if you need assistance in other states. So I hope that was helpful. I hope you all have a wonderful day, and we'll see you next